Vette versus Sanders is a case that LDF litigated in the 10th Circuit Court of Appeals that stemmed from an excessive force by an officer in the course of arresting our client, Eric Tyler Vette. Mr. Vette was arrested on a number of misdemeanor charges that were all nonviolent offenses. And after the sheriff, who was the defendant in the case, put him under arrest and actually was able to fully subdue him, Mr. Vette alleged in a verified complaint that he swore to under penalty of perjury that the sheriff punched him in the face, hit him with the dog chain, and then released a canine police dog to bite him several times on the shoulder. The officer moved first to dismiss the complaint, and then after that motion was converted to one for summary judgment, sought summary judgment, arguing essentially that Mr. Vette's version of the facts was not true. The officer alleged that he never punched Mr. Vette, he didn't hit Mr. Vette with a dog chain, and that while the canine did bite Mr. Vette, it was a brief and fleeting encounter that resulted from an accidental release of the dog. So the district court, when faced with those competing narratives, decided that summary judgment was inappropriate because at summary judgment, the district court's role is not to credit one side's version of the events or over the other. The district court's supposed to look at what is in the record, and if there is a dispute of fact, then a case should go to trial. And here, Mr. Vette had testified in his verified complaint that he swore to under penalty of perjury that a certain set of things happened, and the officer had denied those. The officer then appealed the decision to the 10th Circuit, arguing that first arguing that his version of events was still true. And second, he argued that even if Mr. Vette's version of events was true, the officer was still entitled to what's called qualified immunity, which is a doctrine that shields police officers and other public employees for violating individuals' constitutional rights, so long as those rights are not clearly established by either the Supreme Court or the relevant circuit. So the officer argued in relevant part that 10th Circuit case law didn't make clear that using that kind of force, punching, striking with a dog chain, and letting a dog bite someone after the moment of their apprehension was not clearly prescribed by 10th Circuit or Supreme Court law. LDF represented Mr. Vette in the appeal, though we didn't represent him before the district court, to help him argue and to foreground the fact that every reasonable officer should have known that after an arrestee is subdued, using that kind of significant force that results in bruising and lacerations to someone's skin is not appropriate. And we argued the case in January of 2021, and in a published presidential opinion in March, the 10th Circuit agreed with us and said that the bulk of the officer's arguments were foreclosed by the fact that there were these two competing factual narratives about what happened, and it wasn't the role of the court to make a determination as to those things. And then on the merits of the qualified immunity appeal, the 10th Circuit agreed with us again, finding that even if there weren't factually analogous cases involving the precise type of force that the officer used in this case, any officer should have known from what the 10th Circuit has said for decades about the use of force on an arrestee, that after the moment that someone is subdued and under police control, there can be no use of force on them. Qualified immunity is an issue that's gotten a lot of attention over the last year as this doctrine that is very protective of police officers and other public employees. LDF has a larger campaign to reform or change qualified immunity, to end it altogether for certain types of employees or for all public employees. And the strategy that we employ is sort of multifaceted. On one hand, there are legislative fixes that have been proposed and have been considered by Congress to end qualified immunity, or by various state legislatures to limit qualified immunity in those states. So LDF works to advocate for legislation that would either abolish qualified immunity altogether or drastically limit the scope with which it can protect police officers. Because qualified immunity is a creation of judges and case law not found in any statute, judges have the power to expand qualified immunity pretty easily by taking the Supreme Court's directives that a case needs to be very, very factually analogous in order to get to defeat qualified immunity. Courts have taken those directives and slowly expanded qualified immunity over the years to the point where now, you see ridiculous decisions coming out of the 5th Circuit, 11th Circuit, other circuits across the country really, finding that even the most minute factual differences between two cases can render qualified immunity appropriate for an officer. One of the more egregious examples that garnered a lot of attention and thankfully was ultimately reversed by the Supreme Court was a case out of the 5th Circuit, Taylor versus Riojas, where the 5th Circuit had previously found that leaving a man in a prison cell that was covered in fecal matter and urine for 33 days without cleaning it violated his Eighth Amendment rights. But then when confronted with a subsequent case where a man was only kept for 6 days in a cell covered in fecal matter and urine without being cleaned, the Fifth Circuit found that because the difference between 33 days and 6 days was significant enough, qualified immunity was appropriate for the officers who did that. So when judges have this discretion to extend qualified immunity or withhold it, LDF's litigation department tries to get involved in cases where we feel like we can make a difference. So in Vette, for example, there were no factually specific cases in the 10th Circuit that involved the exact type of force used here. And that's a situation where, the Supreme Court's directives on qualified immunity made it unclear. The 10th Circuit probably could have found that the lack of factually specific cases and exactly analogous cases was sufficient to render qualified immunity appropriate. The importance of that and other cases about the qualified immunity doctrine, specifically as it relates to police officers, is sort of twofold. First, the main way that we enforce our rights in America, the main way that any of us enforce our rights, is through private civil action. So the ability to sue someone who violates your rights for some kind of relief is one of the foundations of American civil rights jurisprudence. Those rights become much, much harder to enforce because of artificial doctrines like qualified immunity. If you have a right to be free from excessive force by the police, but if the police are violating your rights in new and innovative ways, and that means you have no recourse, those rights become a lot less protected. So what we do by litigating against and trying to limit the scope of qualified immunity is make sure that in those situations where people's rights are violated, where people are wronged by police, they'll have a way to get relief. And second, cases involving police misconduct for us are important in and of themselves, leaving aside the qualified immunity issue. Because the more we can define the scope of what police officers can and can't do under the Constitution, the more protective of individuals the law will become. The more we can clarify that police officers can't use force on someone who's already under arrest, someone who's already been handcuffed and restrained. For me, the thing that felt most meaningful about the case is that I think what a lot of people don't recognize about qualified immunity appeals that happen in this way is that so many of them involve pro se litigants, people who are representing themselves. So in a lot of these cases, the power imbalance of having one side representing themselves and having lawyers being paid by the hour and very experienced in federal litigation on the other side, that's often what decides the appeal. It's not the actual merits of the case, but it's the fact that one side has lawyers and the other side doesn't. So talking to Mr. Vette, our client, and reading through what happened to him, it was so clear to me that his rights had been violated. But, he's someone who doesn't have a law degree. He doesn't have the exact format of how you present legal arguments to a court in his head. And so a different combination of circumstances, a different district court judge, a different panel of the 10th Circuit could have really looked at his papers and said, it's not organized the way we know, it's not polished, it's not, typed up, and said that they don't want to deal with it. And that happens to so many pro se litigants in this country. So for me, the most impactful part of getting involved in Mr. Vette's case was the ability to take someone's experience and help them not be defeated by just more power and more, essentially more access to the legal system on the other side.